Hello, everyone, and welcome back from break. Thank you for joining us on the last day of this forum. My name is Raymond Valerio, and I will be moderating the legal panel presentations and the Q&A session. A brief background for me: I have been an assistant district attorney in New York City, in the Bronx, and then the Queens district attorney's offices since 2004. Currently, I am the Director of Forensic Sciences with the Queens District Attorney's Office, where I oversee all forensic-based prosecutions. I collaborate with the Conviction Integrity Unit and the Cold Case Unit, and act as liaison to various entities, including the New York City Forensic Biology Lab and the NYPD Laboratory. I've taught at various professional meetings, including the National Association of Attorneys General National Forensic Science Symposium, and the American Academy of Forensic Science Annual Conference, as well as taught classes at various agencies, including the U.S. Attorney's Office and NYPD Police Academy. Today, we have presentations all revolving around the legal aspects of firearm and toolmark evidence and testimony. If you have any questions for our presenters, please type them in the chat, and we will get them answered during the Q&A session after all the presentations. Our first presenter is Amie Ely, who will be discussing an overview of court decisions related to the admissibility of firearms and toolmarks since the PCAST report. Amie Ely is a director of the Center for Ethics and Public Integrity at the National Association of Attorneys General. She also leads the National Association of Attorneys General's efforts to establish and manage the National Institute of Justice's National Center on Forensics. Through the National Center on Forensics, she focuses on providing forensic science-related trainings and resources to prosecutors and judges. After majoring in psychology, biology, and neuroscience at Oberlin College in Ohio, Amie attended Cornell Law School. She then clerked for federal judges in the Southern District of New York and the Second Circuit Court of Appeals before joining the U.S. Attorney's Office for the Southern District of New York. As a federal prosecutor, Amie focused on violent and gang-related crimes and often introduced forensic science evidence at trial.
Good afternoon. My name is Amie Ely. I'm the director of the NAG Center for Ethics and Public Integrity and the NAG associate to the NIJ National Center on Forensics. Today, I'll be providing an overview of firearms and toolmarks admissibility decisions after the PCAST report. To get a little bit more deeply into what we'll cover, we'll be talking about the case law that's developed since the release of that report. We'll talk about briefly some potential amendments to the federal rules of evidence and the federal rules of criminal procedure that may be of interest to forensics folks. And then finally, I'll talk a little bit about the NIJ National Center on Forensics. So just a quick recap for those of you who may not be as familiar with the PCAST report. In 2016, a report was issued that announced new standards to use to determine if certain forensic science disciplines are foundationally valid, and then if a particular expert in the scientific discipline should be permitted to testify. The report then applied these newly announced standards to forensics disciplines and then made recommendations to federal prosecutors and judges and to federal agencies. In applying those new announced standards to the disciplines, the PCAST folks found that certain disciplines were foundationally valid. Those disciplines were DNA analysis of single source and what they called simple mixture samples, or just two-person samples, and latent fingerprints. The other forensic science disciplines that PCAST examined, they determined were not, in their view, foundationally valid. Those included firearms identification, among others. So in the years since then, there have been a number of decisions that have addressed the PCAST motions, as I've sort of termed the Daubert admissibility motions or Frye admissibility motions that are often made by defense counsel about whether certain forensic science disciplines should be admitted. And then I'll spend some time now talking about the 94 decisions that we've been tracking. Those include 40 decisions issued by federal courts, including decisions by 4 separate federal courts of appeals, and then 54 decisions by state courts, including decisions by 5 different state Supreme Courts. Decisions have been more in the pretrial setting. They've been more these the trial court's issuance of whether something will be admitted in, whether there will be limitations imposed on what an expert can testify about. There have also been, as here, a number of appellate decisions, a few post-conviction decisions, and one mid-trial decision. So determining the criteria for inclusion of these PCAST decisions, we've required access to a written decision or an oral transcript or an oral ruling. And then those decisions must either mention or relate to PCAST. We have chosen to include a few decisions where PCAST was mentioned in the briefing, or when other courts are relying on a decision as kind of what a pronouncement by, in one example, a state Supreme Court has made in the sort of post-PCAST world. So this is kind of the universe that we're looking at for these PCAST decisions. And you can see here that the disciplines are varied, but Firearms Toolmarks is really the place where there's been the most action in these PCAST motions, with DNA, fingerprint, and others being sort of much smaller. So when we look a little bit more closely at the firearms decisions, again, more of them are in the pretrial setting. That is oftentimes pretrial decisions that have to do with, again, after a Daubert or a Frye motion has been made. There are also a number of decisions by courts of appeals, and I'll talk about those at a little bit greater length during this presentation. Obviously, the appellate decisions are going to be setting precedent for, in some cases, an entire state or an entire federal circuit, or in other cases, with some of these intermediate courts of appeals, sort of subsets of certain states. So since those are going to likely have more effect on other cases, I'll spend a little bit more time talking about those. So the appellate decisions, for the most part, have been affirmances of trial court decisions. There have been a few where the courts have concluded that there was harmless error. Two of those, the court said if there was error, it was harmless. We don't have to decide whether there actually was error, because if there was, it didn't make a difference. And then there were a couple of decisions in DC where indeed there was error here, but we're going to find that error harmless. So those are two sort of minor distinctions that nonetheless kind of put these four cases under the harmless error, into the harmless error bucket. And then there were four decisions where convictions were reversed. So I'm going to start by talking about the federal courts of decisions. And for those of you who are less familiar with federal court practice, we have a map on the screen here that gives you an idea of where each of these circuits is located. So the first case that I'll talk about is from the 7th Circuit, Wisconsin, Illinois, Indiana. So all the federal district courts in in those three states will be looking to the 7th Circuit for guidance about what they ought to be doing. So in U.S. v. Brown, the Court of Appeals concluded that while the defendants brought the PCAST report to the district court's attention, the district court chose not to give it dispositive effect, and that choice was within its set of options. In another decision issued after the PCAST report in the 9th Circuit in U.S. v. Johnson, and again, the 9th Circuit is all these blue states here, the court held the trial court properly admitted testimony of a government expert that a test-fired bullet matched a bullet recovered from the crime scene to a reasonable degree of ballistic certainty and didn't abuse its discretion in denying the motion to exclude the expert's testimony, which was based on the AFI methodology. And then finally, in case over here in the 2nd Circuit, where I used to practice, New York and other states in that area, the Court of Appeals held that it wasn't an error to choose not to conduct the Daubert hearing or to allow a government expert to testify that he reached his conclusion, again, to that reasonable degree of certainty in the field of ballistics. This was one of those cases where the defense and the government talked about PCAST in the briefing some, but it wasn't actually addressed by appeals. And I should note, in both of these second two cases, the 9th Circuit and the 2nd Circuit case, the court said it was okay to use this reasonable degree of ballistic certainty language. That is not what is being permitted at this point by the U.S. Department of Justice under the Uniform Language for Testimony and Reports. So just note, if you are testifying in federal court, you really should be talking with your federal prosecutors about whether it's appropriate to still use that language if you're inclined to do so, your Firearms and Toolmarks examiner. So there are a couple of state Supreme Court cases where PCAST has sort of come up. In Garrett, while the court itself didn't address PCAST, the courts in that state have kind of looked to it for post-PCAST guidance. There, the Supreme Court concluded that Daubert hearings were not generally required for Firearms Toolmarks because the court takes judicial notice of the science of Firearms Toolmark evidence and how long it has been admitted in court. In State v. Wheeler, the Nebraska Supreme Court also affirmed a conviction. And we talk a little bit here about what happened in the trial court. And that's that at the hearing before the trial court, the defense argued that the government expert wasn't qualified to opine on the fact that 7 shell casings were fired from the same gun. The trial court allowed extensive cross-examination on the hearing about the PCAST report, but then concluded that the witness was qualified to testify and to render an opinion about those shell casings. The Nebraska Supreme Court affirmed, finding that the expert's testimony wasn't prejudicial, supported the state's theory, and that the defendant had ample opportunity to cross the expert and to present his own theory to the contrary. There have also been a number of intermediate courts of appeals that have affirmed convictions where Firearms Toolmarks evidence was admitted in the sort of post-PCAST world. They include State v. Mills in Missouri, Williams v. Commonwealth in Kentucky, which is the case that construed that Kentucky Supreme Court decision I just talked about, State v. Hatfield in Washington, Rodriguez in Illinois, and Allen in Louisiana. And we'll provide these slides to you. We don't have as much time as I would like, so I don't want to belabor the point too much, but these were all cases where these intermediate courts of appeals affirmed convictions, finding that there was no to hold a Daubert hearing or to hold a Frye hearing to determine whether this evidence was admissible. Now, there have also been a number of affirmances after trial courts required pretrial admissibility hearings, including State v. Castro de Jesus in Washington. This is actually an affirmance of one of the very first mid-trial PCAST motions. Williams v. Texas, State v. Boss in Missouri, and State v. Eaglin in Louisiana. And again, these were all instances where these intermediate courts of appeals affirmed convictions after there were pretrial admissibility hearings sort of in the wake of the PCAST report, during which the trial courts allowed in the evidence from the Firearms Toolmarks examiners. So there have also been a few cases where convictions have been affirmed on plain error, that is that the defense counsel didn't make sort of a PCAST motion before the trial court. And then there have been several reversals, and these are also really important, so I'll spend a little bit of time talking about them. So in Abrukwa, the Maryland Supreme Court remanded a case because that state had changed from being a Frye state to being a Daubert state. Now, there'd been a lot of litigation about PCAST before the trial court. The Intermediate Court of Appeals had also talked about PCAST in its decision. The state Supreme Court didn't talk about PCAST, really just talked about the fact that they were changing from being a Daubert, from being a Frye state to being a Daubert state. And I will note there's a little bit of a footnote here, and that is that this has been remanded. The trial court has affirmed the conviction, finding that the testimony was just as admissible under Daubert as it was under Frye. So this is a case where, again, it's really just sort of the change in the standard of admissibility from Frye to Daubert, but PCAST is certainly a part of the arguments that are being made, and for at least the trial court and the Intermediate Court of Appeals, some of the things that the judges are grappling with. Now, State v. Rayner is a Connecticut Supreme Court case. There, the court remanded for admissibility hearing, citing both the NAS report and the PCAST report, and approved of a more likely than not standard. So in Connecticut, there's at least a suggestion that this limitation on what Firearms Toolmarks examiners would be testifying to is appropriate. Then we also have an Intermediate Court of Appeals decision in California, Ascana, where the court concluded that the trial court committed multiple errors related to the firearms expert, including allowing testimony about conclusions that were not supported by the evidence, allowing in sort of inappropriate hearsay. The court was careful to say, we're not saying that Firearms Toolmarks is per se inadmissible, but we're saying that the way that it was admitted here doesn't pass muster. So that was a reversal. And then finally, another Intermediate Court of Appeals, this time in New Jersey, affirmed a decision to have a Frye hearing for the bullet track software, but then reversed the trial court's decision to require discovery of the algorithms and to limit the expert's testimony. So while this is a reversal, it's not something that is likely to cause problems for people who are trying to put in Firearms Toolmarks evidence. Now, we've covered now the universe of these appellate decisions. I'll go fairly quickly through the pretrial decisions. These may be of greatest interest to those of you who are our examiners, because these are the decisions that your trial courts are actually issuing that oftentimes as I'll discuss, may limit what it is that you have to say. But other than being sort of persuasive to other courts, they're not really binding on other courts. So they're a little bit less important maybe for the lawyers in the room, other than what you might be able to learn about some of just good practices for introducing this evidence. So we've got a total of what I end up sort of collapsing into 14 federal pretrial decisions, including one mid-trial decision that I'll analyze in this section, and then 16 state pretrial decisions. The motions are typically by a defendant to exclude or limit a government firearm toolmarks expert. There are a few cases where the government has moved to exclude a defense expert, oftentimes someone who's interested in talking about the PCAST report. Then there are a couple of civil cases that I won't discuss today. I have not found any full exclusions based on these PCAST motions, but it is relatively common for courts to limit the testimony of a firearms toolmark examiner. I'll ask that if you are aware of any full exclusions, please contact me. I'm interested in getting my arms around as many of these cases as possible. So some of these limitations are either just the expert or the government agreeing to things like the uniform language for testimony and reports, or a court actually ordering an expert to abide by certain limitations. So for these federal admissions, there are 3 cases that we found where courts just admitted testimony by firearms toolmarks experts without any sort of limitations in Nevada, Illinois, and Michigan. And then there are 4 cases where the courts admitted the testimony, but the government agreed to, or the expert agreed to abide by certain limitations. Again, oftentimes the ULTR, the Uniform Language for Testimony Reports. You can see that here with the Harris, the Hunt, the Johnson, and Ricks v. Pouch cases here. And again, I've got these categorized as places where really the government or the government's expert said, we are agreeing not to testify beyond a certain point. Now, there are other cases where the court imposed limitations, and here really the devil is in the details. We have everything from White, where Judge Sweet in the Southern District of New York said that the expert cannot testify to any specific degree of his conclusion that there's a ballistics match between the firearms seized and those used in various shooting incidents. So the expert was allowed to even use the word match, but couldn't as to any specific degree of certainty. There are a few others in the middle here, Medley and Ship, that sort of are limiting things more and more. And then we have down to Davis and Adams cases in Virginia and in Oregon, where the courts limited what the expert could say even more sort of forcefully. And in the states, we too have a number of cases at the trial level where courts just admitted firearms toolmarks testimony. Got some cases up here from Virginia, Kentucky, Missouri, Colorado, and then a couple of cases from Massachusetts. And then again, there were also trial courts where there were limitations imposed. And once again, it's really the I think experience for the examiner and the experience for the prosecutor and the experience for the defense attorney can drastically really depend on how much of a limitation is required here. So in Terrell, for an example, a Connecticut court permitted a common origins testimony, but would not allow the examiner to say that it was practically impossible that another firearm fired the casing in question. And we sort of get more and more restrictive as you go through these cases on this slide, down to Ross and AM, a couple of cases in New York, where the judge permitted only class characteristics. So again, depending on how the judge decides to limit, the testimony can be either fairly close to what I expect the examiner expected to be saying, or quite limited. So there's also been at least one firearms case where a judge has excluded a defense expert who proposed to testify about the PCAST report. And then in firearms toolmarks, while I'm not talking about those cases generally, there are several federal cases where a defense expert was proposed to testify the PCAST report, but the trial court excluded that evidence sometimes because of hearsay or relevance arguments. So if you're somebody who's litigating these things, it may be useful to kind of look at what's happening in some of these other disciplines if you're addressing PCAST motions. So that is the PCAST overview. I look forward to talking with folks during the Q&A about some of these cases. And I'll move now to an update on the federal rules of evidence and federal rules of criminal procedure that may be useful for folks who are interested in firearms toolmarks to be aware of. So why does this matter? Well, in federal court, as many of you know, Federal Rule of Evidence 702 sets the criteria for admissibility of expert testimony in all federal criminal and civil cases. Federal Rule of Criminal Procedures 16 sets the sort of discovery requirements for expert testimony in federal criminal cases. In state courts, many states have sort of analogs to Rule 702 or a discovery rule that's kind of like Federal Rule of Criminal Procedure 16. So defense attorneys may be arguing for a change in those standards, and the states may amend their own analogous rules, and defense attorneys may just argue that if things are happening on the federal level, the states should in any particular be held to those sorts of criteria. So there's a very long history to the amendments to Federal Rule of Evidence 702, which I will not get into. I will instead give you sort of a snapshot of where things stand. So what I have on the screen now is the current Rule 702 with the proposed edits underlined. So what the proposal is at this point is that there'd be a change to include that the proponent has to demonstrate by a preponderance of the evidence that an expert's scientific, technical, other specialized knowledge will help the trier of fact, et cetera. The testimony is based on sufficient facts or data, and the testimony is the product of reliable principles and methods. So those A, B, and C are language that currently exists and that would stay. And then there's a small change proposed for D, which is really not particularly material, but allows for a comment in the notes to the rule, which I'll get into in the next slide. All right, so let's talk about what these notes are actually saying now. So there would be sort of additional emphasis placed on the fact that courts really do need to be looking at this evidence to make sure that it should be admissible. So why does that matter for firearms toolmarks examiners? Well, to the extent that courts have been looking at questions of admissibility, maybe more as a question of weight. That is, we're going to let this evidence in, but defense counsel will be able to cross on these points. Courts may be looking more carefully to determine whether the evidence should be allowed in at all. And the fact that the committee is sort of highlighting that courts really do have this gatekeeping rule may cause courts to look a little bit more carefully at evidence that they've been willing to allow in the past. The rule also reminds courts that the evidence only needs to help the trier of fact, only needs to help the jury oftentimes to understand the evidence or determine a fact at issue, that you have sort of a higher burden than that. So in that way, it may actually sort of increase a little bit admissibility of expert testimony. Now, what I think will be most interesting to the folks in this room is the emphasis on forensic science that's also proposed in this sort of addition to the note that would be appended to Federal Rule 702. And here I'm asking the actual language of the proposed note. And that is, the amendment is especially pertinent to the testimony of forensic experts in both criminal and civil cases. Forensic experts should avoid assertions of absolute or 100% certainty or to a reasonable degree of scientific certainty if the methodology is subjective and thus potentially subject to error. So they're really sort of saying that this reasonable degree of certainty that the Ninth Circuit, that the Second Circuit said was okay, is not a good idea. And then the note also notes that a judge should, where possible, receive an estimate of the known or potential rate of error of a methodology based on studies that reflect how often the method produces accurate results. And I think this next note is particularly important. It reads, expert opinion testimony regarding the weight of feature comparison evidence, i.e. evidence that a set of features corresponds between two examined items, must be limited to those inferences that can be reasonably drawn from a reliable application of the principles and methods. So this note really does, I think, empower judges to make some of those limiting decisions that we talked about for some of those trial court decisions. It's really telling judges that one of your jobs is to make sure that the experts do not overstate the evidence. And then finally, the note says that we're not going to be barring testimony that comports with substantive law requiring opinions to a particular degree of certainty. That means is that if the Ninth Circuit and Second Circuit choose to still require experts to use that reasonable degree of, say, ballistic certainty language, the note isn't purporting to sort of overturn that. It's just earlier in the note saying that we don't think it's a good idea. So I'll very briefly go through some of the proposed amendments for discovery for forensics and other experts in federal court. The proposed rule, Federal Rule of Criminal Procedure A1G, would require the government to abide by a time to make disclosure and require courts to set that time. That time has to be sufficiently before trial to provide a fair opportunity for the defendant to meet the government's evidence. And then there's a little bit more about the content, what actually needs to be in this Rule 16 disclosure. It's got to include a complete statement of all opinions that the government's going to be eliciting from the witness, the basis and reason for those opinions, the witness's qualification, including a list of all publications authored in the previous 10 years, list of all other cases in which during the previous 4 years, the witness has testified at an expert or by deposition. And then the witness is generally required to sign the disclosure. Similar requirements are in the note that governs what defense attorneys need to provide to the government. So if these are sort of new requirements for you, if you're a Firearms Toolmark expert, know that if this rule is passed, that you're going to need to make sure that you have this information to provide to any federal prosecutors for whom you might be testifying. Now, there are a number of states that have analogous rules to this Rule of Criminal Procedure 16. It stands to reason that if the rule is changed on the federal level, that some of these states may be looking at their rules as well. You may just have slightly more fulsome discovery obligations. So in the last couple of minutes, I want to talk just a little bit about the NIJ National Center on Forensics. The primary purposes for the NCF, as we call it, include providing medical legal learning opportunities for medical students to train as deputy MEs or coroners in underserved rural areas, providing forensic science and legal training to prosecutors, judges, and law enforcement, and finally, to develop opportunities as appropriate amongst the partners to benefit current and future practitioners in the field. The grant itself is a cooperative agreement, so we're working closely with NIJ. It's for 3 years. We're finishing year number 1 as I speak. And our partners include George Mason University, who's the lead on the grant, my association, the National Association of Attorneys General, the American Society for Clinical Pathology, and the Montana Forensic Science Division. And then we work with a number of different partners, including a couple of the affiliates listed on the screen now. At this point, we have finished our needs assessment for the legal community, which includes law enforcement, prosecutors, judges, and the like. And we're moving into developing training and resources for the folks who we're helping and for the folks who we're training. We expect that the trainings will address the areas that we've identified through the needs assessment process, and they'll be primarily online in 2022. We hope to be able to do a big in-person training in 2023. The resources that we expect to provide will again be those that are responsive to the needs assessment. We expect that they will include a public database that will address the PCAST decisions. So we're looking to provide a chart that will allow you to kind of see what's happening on your own time in these cases. We may also include things like some information about which states are using FRI and which states are using Daubert. So I really look forward to the conversation that we'll be having, and appreciate being able to share the stage with Jim and Ray, who are really fabulous. Thank you very much.
Thank you, Amie, for your presentation. Your overview of admissibility case law was very clear, helpful, and informative. If you have any questions for Amie, please type them in the chat and we will get them answered during the Q&A session. I have the pleasure of the final panel presentation for today. During my presentation, I will be discussing some of the current challenges to firearm and toolmark evidence. Welcome to Firearm and Toolmark Evidence, Admissibility and Current Challenges. This presentation comes in response to increased challenges in this forensic discipline. As we already can see, it has become the challenge du jour. In this brief talk, we will discuss 2 of the primary areas that are challenged in court. 1 are the validation studies and inconclusive decisions. and second, the relevant scientific community. The first challenge is simple. They say that the validation studies are faulty. They're designed poorly, and they don't count inconclusive decisions appropriately. Now, we are familiar with PCAST. They discuss several forensic science disciplines. They said for foundational validity, multiple black box studies are necessary. But in firearm and toolmark analysis, only a single appropriately designed study existed, and that multiple independent black box studies were necessary. DOJ released a statement in 2021 explaining why PCAST was erroneous. They said, PCAST's claim that forensic pattern examination methods can only be validated using its non-severable set of 9 experimental design criteria is inconsistent with its own examples, international laboratory standards, and authorities in experimental design. There is no single scientifically recognized means by which to validate a scientific method. Now, the former co-chair of PCAST, Dr. Eric Lander, reiterated PCAST's point in the Fordham Law Review. He said, with only a single well-designed study estimating accuracy, PCAST judged that firearms analysis fell just short of the criteria for scientific validity, which requires reproducibility. A second study would solve this problem. Single study fell just short, and a second study would solve this problem. That was 2016, 2017. Now we're in 2022. Where do we stand? Here is a list of several firearm and toolmark studies over the last 20 years. There are many different design here of the studies, closed set, open set. There are also 3D studies that are not captured on this chart. For the sake of argument, let's play by PCAST rules and just look at the black box studies that meet their criteria. We know in 2014, they credited the Baldwin study. But since PCAST, Kiesler published a study in 2018. Again, a black box study. Then Smith in 2020 published another black box study. And I note that all of these had extremely low false positive error rates. Last year, the FBI's Eric Smith presented their mega black box study at the 2021 AAFS annual conference, and then in more depth at this conference. Over 20,000 comparisons with a false positive error rate of less than 1% for bullet comparisons and for casing comparisons. In 2022, not only do we have enough appropriately designed studies to demonstrate the reliability of the discipline, but the false positive error rate is well below PCAST's acceptable range. You remember that PCAST said that the false positive error rate should be less than 5%. That has been satisfied. But despite this research, criticism still exists. But now the critics must shift the goalposts. So inconclusive decisions are now under attack. Firearm and toolmark examination is not binary. In FSI Synergy, Drs. Dror and Skurich argue that inconclusive decisions are errors since ground truth is known. They argue that inconclusive decisions in these validation studies allow participants to skip the answer. However, if that were the case, sensitivity would capture this. Examiners were saying inconclusive too often, the sensitivity would be very low. Yet, the sensitivity in the Kiesler and Baldwin studies are about 99%. Todd Weller and Dr. Max Morris responded to Dror and Skurich by making the point that, quote, insistence to classify all decisions as correct or error is overly simplistic. Dror and Skurich responded to Weller and Morris, but didn't address their points. And then Biederman and Katsuglu, again, added on their critique to Dror and Skurich in the same journal. Let's look, for example, at the Baldwin study. They recognize that many of the casings marked poorly, or consider the FBI study and how they focused on hard errors, only false positives or false negatives. Why are these approaches correct? First, inconclusive is a legitimate conclusion in firearm and toolmark analysis. We see that in these examples here. I'll note that inconclusive decisions are found in many scientific fields, including DNA analysis with mixture interpretation, analytical and stochastic thresholds. We also see it in drug chemistry, pathology, and other fields. Second, study designers do not review every casing and bullet. We saw that in Baldwin just now. We know that certain firearms and ammunition just don't mark very well. And every study participant gets a different set to examine in these studies. We just don't know if one set marked better than another. Third, inconclusive decisions are a good thing. We want cautious examiners. This is reflected in casework. Finally, inconclusives do not lead to wrongful convictions. In other words, inconclusive decisions in these studies are not the problem. Now, if we play by PCAST rules, they count inconclusive in the denominator, not as false positive error. You see here, they say that false positive rates based on the proportion of conclusive examinations. Let's play this out with the Baldwin study. Baldwin sees 2,178 different source comparisons. And this is how they calculate the false positive error rate. It comes to 1.01%. Using the PCAST methodology, they remove the 735 inconclusives, and the rate slightly goes up to 1.5%. But if we use the drawer-Skurich methodology and add the inconclusives to the numerator, it would balloon the false positive rate to 34.8%. The only way to get the false positive error rate above 5% is by adding inconclusives to the numerator, as Drawer and Skurich suggest. And I'll add that none of the validation studies that we talked about consider technical review. So I pose this question: what would the false positive error rate be with technical or peer review? My position is that it would be vanishingly low. Finally, if the results in any specific case were inaccurate, would not an opposing expert be the appropriate person to expose that inaccuracy? We have to harken back to NRC 2 from 1996, the DNA report. And what they said on page 87 under ensuring high standards was that a wrongly accused person's best insurance against the possibility of being falsely incriminated is the opportunity to have the testing repeated. We know in DNA, often the evidence is consumed, whereas in firearm and toolmark analysis, the evidence is never consumed. There's always an opportunity for a second expert, a defense expert, to review the evidence to see if they should come to a different conclusion. Isn't the critical question in any case whether this result in this case is correct? Now let's talk about the relevant scientific community. Here, the challenge is simple. It's that the relevant scientific community does not approve of firearm and toolmark analysis. There are a handful of people that have testified as defense experts: law school dean David Fagman and psychologist Nicholas Skurich, to name two. But even with long CVs, are they really part of the relevant scientific community? The question truly is, who is the relevant scientific community? Many courts across the nation have discussed that issue and recognized that relevance is key. Analogies help here. If you needed a root canal, you would see a dentist. You wouldn't go to a cardiologist. The cardiologist might be very well trained and accomplished, but is unable to perform the root canal. If a merger and acquisition is the legal task, you wouldn't call a prosecutor, even if the prosecutor had 20 years of experience practicing in the same jurisdiction. If you needed to build a bridge, you wouldn't call an electrical engineer. I think you see where I'm going here. In other words, experts are not fungible. There is a reason why we give credence to experts in specific fields. Forensic science is not different. A tiered wedding cake is a picture of one way to explain what the relevant scientific community is. Think of the entire field of science. At bottom would be anyone with a Bachelor of Science degree. Moving up, you'd have people with masters and PhDs. Then practicing scientists, chemists, biologists, cancer researchers. Then we get to people who are specifically involved in a forensic science discipline. Here, we have researchers specifically in firearm and toolmark examination. These could be all different types of scientists, but specifically those doing the work and the research in that field. And these people are influential because they have no skin in the game, so to speak. Above that would be people in forensic oversight. We're talking about quality control managers, lab directors, state forensic science commissions, people whose specific job it is to ensure quality work comes out of the laboratory. Then above that would be the firearm and toolmark examiners themselves. I argue that the top three are the relevant scientific community. Everything below that is like getting a root canal from a cardiologist. And the relevant scientific community says that the discipline of firearm and toolmark analysis is reliable. Thank you for your time.
Thank you, Amie and Ray. I know that anything scheduled for a Friday afternoon had better be worth it, and the two of you certainly did not disappoint us today. For the audience, if you could continue to type your questions into the chat, and we will begin our question and answer session. For Amie, if an audience member said in their experience they know of no examiner who wants to answer the question, "Are you sure to a reasonable degree?" But this question is still often asked in court. How does an expert respond when asked to say yes or no to this question?
I think that's actually not an easy question to answer. I'd say first, it's a really good idea, and I tell this to prosecutors as well, to have conversations with your prosecutor ahead of time. I know sometimes it can be difficult for people to make time to do witness preparation, but it is just really, really important. And bringing that question up to somebody who is familiar with what the case law in the jurisdiction requires, I think is really important. There may well be some circumstances where courts are still requiring that language. And even the amendments, or the proposed amendments to Federal Rule 702 kind of acknowledge that it's possible that there are some courts that still require that as a matter of sort of case law. So while the uniform language for testimony and reports doesn't allow that, and if those sorts of things are happening in federal court, the U.S. Attorney's Office candidly shouldn't be supporting that. If it can, again, with the caveat that if that's what the courts in that jurisdiction require, there's a carve out for that. I guess the short version is there can be circumstances where you would have to answer that question, but it's really a question for you to sort of front with a prosecutor who will be sponsoring your testimony, because if that's what the sort of courts of appeal in that jurisdiction requiring, you might be sort of stuck with it. I don't know if that answers the question well enough for the person who asked it, but it's somewhat of a lawyerly answer, which is it depends, but be sure to talk with your prosecutor if you can ahead of time.
Great, thank you. Ray, in light of all of the validation and black box studies that have been conducted since the PCAST report and the Fordham lab review, in your opinion, why is firearm and toolmark evidence admissibility still an issue?
I think that challenges to forensic science are to be expected. I don't think that this is a unique question for firearm toolmark evidence. We see this in all different forensic disciplines. Just by way of experience, for instance, in DNA analysis, there have been a multitude of challenges to our use of DNA science, even though there have been dozens of courts that have approved the current technology that we're using in New York City. But yet we still regularly have to respond to different challenges to that type of evidence. So I don't think it's unique. I will say that I think that the challenges that we do receive make us better, both as attorneys, because we've sharpened and focused on the most salient issues. And I think it actually helps out the community in general because it makes us better. So I don't think that we should be so concerned that there are challenges, but that we take the challenges, we answer the challenges as best as we can. And I think we see that through Eric Smith's study and many of the other speakers that we've had over this week. All of the work that's being done is supporting the reliability of the discipline. And when we, especially as prosecutors that are offering this evidence, understand that as we should, then we're able to then convince, hopefully, a judge that this is reliable evidence that we can use in court.
Great, thank you, Amie. Sticking with the PCAST theme, you mentioned that there are around 50 instances of court cases since PCAST. Is that the total number of times that firearm evidence was used or rejected in all U.S. courts in criminal cases?
In a word, no. This is an answer I can actually give a short answer to with a little bit of follow-up. So we've tracked around, and when I recorded this, it was about 94. We're up to 96 or 98 decisions in cases where that we kind of defined as PCAST cases. For us, those include only cases where we can either get a written decision or we can get the transcript of an oral decision. So the number of cases where there have been PCAST arguments, but there haven't been sort of decisions that are published or that we learn about, I'm sure are much, much higher than the 100 or so that we're aware of. And then that 50-some number is actually the number of firearms cases that we were able to identify that fit our criteria as being sort of PCAST cases where we had that information about those decisions.
Thank you. Back to you, Ray. If a cartridge case is determined to be inconclusive with one firearm, but are subsequently identified to a second firearm that was submitted, would this be acceptable?
Well, if I understand the hypothetical appropriately, it seems like a cartridge case is compared to two separate firearms, but the examiner's conclusion is that one is inconclusive and to the other one, it's identified. I don't see anything inconsistent about that on its face. Just because something is inconclusive, it's just that. It's not an identification. It's not an exclusion. I think this is supported by the studies, even Eric's study that he discussed today. So I don't think that that's inconsistent.
Great. And for Amie, would we need to provide all of our testimony or just any federal court testimony for the federal rule criminal procedure 16 change that you mentioned?
All of it. There isn't a restriction in the proposed rule change to being only the federal court testimony. So it would be basically transcripts of any testimony that you provided within, I believe, the last 4 years. This is, as 702 is, a rule that is currently under consideration. So you can look into how to provide any sort of input to the decision makers about whether that sort of rule change would be wise.
And this next question I'll throw up to either or both of you. Are there any studies that assess the impact of non-blind technical reviews and whether this affects verifying false identifications?
Well, I'll take a stab at it, Amie. I'm not aware of a study that specifically answers that question. But if you just zoom out a little bit, as I mentioned in my talk, the studies, the black box studies that exist, are not even considering this peer review as a secondary kind of QA check. So maybe this is a design of a study that someone who's listening today wants to undertake. But I think it's a good question. Of course, every lab has different protocols, whether they're going to peer review every conclusion, a percentage of conclusions, just identification conclusions. So there's kind of a variety of different lab protocols. Of course, it depends on the lab and the resources and a host of different things. But I don't know of one that currently exists.
Great. And for Amie, based on the limitations to testimony that you outlined in your presentation, if the ULTRs were universally applied to testimony in both federal and state courts, would that not eliminate the need for judges to impose these limitations and other adverse decisions?
That is a really interesting question, and I wish it would have been one that we were provided with ahead of time, because I think it's something I'd really like to think about a lot more. And I didn't, when we were analyzing the decisions, we didn't look at them kind of thinking about if that was the gloss that was placed on them, what the result would be. I mean, there are also some differences, right? I mean, I think that the U.S. Department of Justice in promulgating the ULTRs took its best stab at ensuring sort of appropriate testimony. Judges ostensibly are working to do the same thing, but they may be thinking about slightly different criteria. They're also going to be presented with whatever it is that the advocates bring to the table. If you have somebody like Ray Valerio, who knows an awful lot about forensic science and is able to bring to the table for the judges the studies that are sort of most useful to assist in introducing the examiner's testimony, you may end up with a different outcome than if you have somebody who was less prepared and less of an expert than Ray. So in some ways, I think if you did just have a universal ULTR gloss on everything, you would have some uniformity. But I think that unfortunately doesn't really take into account the role that the judges are required to play under, for example, Federal Rule of Evidence 702 or the state equivalents to do their own sort of gatekeeping on this type of evidence.
Great. And Ray, why do you think inconclusive decisions in firearm or toolmark cases have received criticism while non-binary conclusion decisions can be found throughout the forensic disciplines?
I think this harkens back a little bit to how I answer the question regarding the current state of the studies since PCAST. The questions that PCAST posed, I think, have been answered by and large through the studies that have come out since 2016. So the challenge has narrowed significantly. But we see this, again, in multiple different fields. Like I mentioned before, in DNA analysis, now that we're using probabilistic genotyping software that's been accepted in dozens of courts, now the challenge will focus in on something more like determining the number of contributors to the mixture of DNA. So just as an example, these challenges narrow more and more over time. The more, maybe I can put it this way, the more research that exists, the more narrow the challenge becomes. And I think we're seeing that here with inconclusives, because the field, including the people who have spoken during this week, have done such a tremendous job of researching and publishing their research and data. And it covers such a wide field of scientists with different backgrounds, from computer science to physical scientists, to all different types of scientists. Because of that, the challenge is down to this inconclusive question. And I think Eric Smith gave an excellent answer. If you were able to listen to Eric Smith's answers regarding inconclusives during the last Q&A session, I think he described very well the fundamental misunderstanding that non-practitioners have when they approach looking at inconclusives in these studies. But when you are somebody who understands at a granular level, not to use a pun, but true, at a granular level, what's happening in this type of analysis, it's not a surprise that you're going to get inconclusive decisions. That doesn't mean that the field in general is unreliable. And that's really key. I think some of this is conceptual. We're looking at reliability. Is this analysis reliable? And based on the studies that exist and the casework that we see, it speaks to me that it is reliable. So I hope that answers the question. But I just say that I don't think that this will be the end of challenges. I think we will see more challenges still in the future, even after this question of inconclusives is resolved. It's just going to change into something else.
Great, thank you. And Amie, also thank you for bringing up the procedure 16 change, because we do have another question on that, which is, what happens if you do not have access to your past transcripts? Is records of when we went to court and for what case would that be acceptable?
Great question. And I may have overstated if I said that you had to provide every transcript. I just took a look again at the proposed change, and it is a list of all other cases in which during the previous 4 years, the witnesses testified as an expert by trial or by deposition. So what you'll need to have is, if there's a case number or whatever type of information that an advocate would need to use to, if he or she wanted, track down those transcripts him or herself. My sense is, and my practice was several years ago when I was operating as a federal prosecutor, was to, if I had access to those transcripts from those previous cases that an expert testified, to actually provide the actual transcript. So my sense is that if you have those transcripts, providing them to your prosecutor is a really good idea. The prosecutor will most likely will turn those over to the defense as well. If you don't have the transcripts themselves, as long as you have that case information, again, the list of all the cases at which you've testified as an expert at trial or by deposition, that should be enough. One of the reasons, by the way, to make sure that also have those transcripts is that there's a very good chance that any good defense attorney should and will track down those transcripts on that person's own. So a good prosecutor should review those transcripts ahead of time. If it looks like there's going to be the sorts of things that you might get cross-examined about in those transcripts, talk with you about those things and deal with them potentially in the direct, rather than waiting for you to be all surprised during the cross.
Great, thank you. And Ray, what minimum criteria does an individual need to testify as part of the relevant scientific community in firearm and toolmark cases? Second part of this question would be, what criteria would you propose to make sure that the testimony is truly from the relevant scientific community?
Sure. I mean, this is a question that is perfect for a lawyer, because it's speaking of relevance. And I think, everybody who answers this question may have a slightly different answer. I will say this: there is no bright line rule. There's no statute that I know of or law that specifically defines what is the relevant scientific community. I'll say this, maybe just using my own personal experience as a young prosecutor, a new prosecutor, if you were to ask me what is the relevant scientific community for firearm and toolmark analysis, I'd probably say practitioners. But now that in my role as director of forensic sciences, I spend a lot of time studying the studies and getting really wading deep into the science and the state of things. And now I would expand it, even as I spoke of in my talk. I think that there are many people, again, that are here at this conference and who have spoken at this conference that comprise the relevant scientific community, and they wouldn't be who we would call traditional practitioners or examiners. But because they've done the type of research that directly touches on the reliability of the field, they ought to be part of that community. So I think it's broader than maybe the way that I would have first approached it and defined it as a young prosecutor. But the more that I've delved into this, I do think it's a little bit broader than that. I think the problem comes when we broaden it to the point of watering it down, and then it's no longer relevant. And this is something that gets argued in court. right? So the prosecutor is going to offer our experts, defense is going to offer up their experts, and it's on the advocate to then argue to the judge what really is the relevant scientific community. Of course, I work in a FRI jurisdiction in New York, so the key question really is the relevant scientific community. Of course, that's one of the Daubert factors. So it's going to be relevant in all different jurisdictions, but there's not a bright line rule. So I think it really depends. But the more I think about it, it's somewhere in between practitioners and everybody. And I tried to encapsulate that in my talk.
Great, thank you, Ray. Amie, for cases that were deemed to have quote unquote harmless errors in appellate courts, what, if any, action is taken after that finding? Since it was deemed as harmless, is there any follow-up regarding the error that was made in that case?
So this is, again, not a quick answer, but I'll try to make it at least as succinct as possible. So with the two sort of ways that we analyze the harmless error decisions, some of them said there was error, but it was harmless. Others said if there was error, it was harmless. So the ones that actually found that there was actual error most likely will not impact that decision. And I say, or impact that case. There are some exceptions to that. It's possible that if in some sort of a post-conviction proceeding, the defense argued that his lawyer had somehow dropped, the defendant argued that his lawyer had somehow dropped the ball by not raising that issue in an appropriate way, that there could be some possible outcome change in the case in which the court decided that the error was harmless. Not particularly likely. However, if an appellate court said there was error, but it was harmless in this case, the appellate court finding that there was indeed error is going to be something those trial courts below that court are going to be looking to decide how to handle future cases. So they can be precedential in that way. The cases where instead the courts say if there was error, it was harmless, we don't have to decide, really don't do a whole lot. I hope that answered that question. I think the harmless error issue is sometimes a little bit tricky for even lawyers to kind of get their arms around.
Great. This next question, I'm going to open it up to either or both of you. How do you suggest we deal with limitation of testimony? The questioner says, we swear to tell the truth, yet if we are only allowed to testify to, say, class characteristics or some quote unquote watered down version of our conclusions, we aren't really telling the truth.
I can jump in on that one first. And I'm actually going to break it down into how different bodies ought to deal with this. So I'm going to start with prosecutors because those are sort of my people. So if there's a situation where a court has really restricted the testimony of a particular firearms toolmark examiner, the prosecutor does potentially have a couple of things that she can do. So if it looks like the court has made some sort of error that a motion for reconsideration might cure, the court has maybe not understood the facts properly, or the prosecutor is aware of some other information that somehow didn't come before the court. That's one thing that the prosecutor might be able to do even before we get down to the time where that expert testifies. There are also some examples, there's some instances where a prosecutor could either seek an interlocutory appeal or seek mandamus of a trial court judge, that is, without waiting for the case to end, go up to the court above to say, hey, we'd like for you to review what it is that this court ruled. Those are really, really dependent on the jurisdiction, really, really dependent on how things sort of played out before that trial court. At the end of the day, the witness's job is to follow the court's orders. And that is true whether you have a firearms toolmark examiner who has had their testimony limited. That's true even if you have, say, an agent who executed a search warrant in a defendant's house and the court ordered that agent not to testify about everything the agent found. So these sorts of limitations happen in other contexts too. And just like an agent testifying only about some subset of the evidence that he found isn't perjury, nor is, in my view, a limitation imposed on a firearms toolmark examiner. I do think the prosecutor needs to be careful about the types of questions that she asks. To use the example of the sort of search warrant execution, a prosecutor faced with a situation where a witness's testimony has been limited by the court shouldn't ask that witness, so tell us everything you found in the house. The prosecutor needs to narrowly tailor her questions so that the witness can answer them truthfully. I think there are still some really good ways for prosecutors and Firearms Toolmarks examiners to deal with these limitations. And I'm grateful that I was given a little bit more information about the Davis case, the Western District of Virginia case that I talked about a little bit during the presentation. That was a situation where the trial court really did limit the Firearms Toolmark examiner testimony, but the way that the examiner and the prosecutor handled that was by showing the evidence to the jury. They actually did a side-by-side of the compound microscope image of the test-fired bullet or casing, and then the bullet or casing from the scene. And the examiner pointed out all of the ways that those two casings or bullets, quote unquote, matched without saying that they matched. And as I understand it, the view was that the jury found that just as persuasive and maybe even more persuasive than if the Firearms Toolmarks examiner had just sat on the stand and said, yeah, in my opinion, that gun shot that bullet. So I think that there are ways, and again, it really does require work and collaboration and time by the prosecutors and the Firearms Toolmarks experts at the front end in kind of thinking about how to deal with these limitations and doing the best work that you can to prevent them. But if a judge rules that you can only testify that something is more likely than not, you're stuck with that. And I know there's been some suggestion that you can sort of trap the judge into thinking that maybe that would be requiring you to perjure yourself. I think that's a terrible idea. And I think it's the type of thing that if and I'll turn over to Ray in just a minute, but I just want to play out this scenario because I think that the perjury sort of temptation is one that everyone should be fighting against. I think the way that could play out is if you suggest during a Daubert hearing or a Fry hearing that if you're limited, you'd be required to perjure yourself. Let's play that out. So let's say the judge does limit you. And then let's say you testify at trial in a manner that is consistent with that limitation, because that's really your only option. I think any good defense attorney is going to stand up and say, so, Mr. Firearms Toolmarks expert, didn't you testify during a pretrial hearing of this case that if you told the jury what you just told them, you'd be perjuring yourself? And the answer to that is yes, right? And that can have real serious consequences for the case. That can have real serious consequences potentially for you as a Firearms Toolmark examiner in your career, because any sort of implication that you have perjured yourself ends up being the kind of thing that oftentimes prosecutors have to disclose. And can be, I think, a really, really big deal. And it's one of the things that I think, I know that there's been a memo kind of going around, but I just hope that folks talk with their lab prosecutors, talk with their prosecutors, or talk with their lab counsel, talk with their prosecutors if that's something that they're at all intrigued by, because I think that the downstream consequences for the cases, potentially for your career, can be pretty serious. So I know that was sort of a long-winded response. I hope Ray has some things to add, and I'll turn the floor over to him if he does.
Well, yeah, that was very thorough, Amie. Thank you. I would just add an overall thought. My experience is that trials are kind of exercising the art of adaptability. We're always, as attorneys, adapting as a trial progresses. So sometimes we get bad decisions, sometimes we get good decisions, sometimes a witness goes sideways and we have to figure out how are we going to deal with that. I mean, this is part and parcel to our job. So when we get a decision that we don't agree with, we have to see how we can adapt to that. Now, Amie gave an example of that West Virginia case. I will admit that the case that Amie mentioned, People v. Ross and AM in New York, that limited the testimony of the examiner to class characteristics, was the Fry hearing that I conducted in New York City a couple years ago. And, we vigorously argued what the state of the science is and what we should be permitted to offer into evidence. The judge rejected our arguments. but yet we still presented what we could present. We were able to do something, even like Amie said, from West Virginia, of showing the actual evidence. So, I think we do the best that we can in adapting to it. But I don't think if at the heart of the question, whoever posed the question was more of an ethical question. I don't think it's an ethical issue. When a judge tells you this is what you can do and this is what you can't do, I don't see any reason why that would be an ethical concern. So if that's kind of the heart of the question, I think those fears should be assuaged, because I just don't think that that's the main issue that you need to be concerned about.
Great, thank you. Ray, I have a two-part question for you. The first part is, what can firearm units do to prepare the legal community for the transition to 3D virtual comparison microscopy? And the second part of that question is, how will 3D VCM impact post-conviction case reviews?
Good, very good question. So just stepping back a little bit, I asked John before the conference started, what was our audience kind of breakdown? Who was here for this week's of conference? And my very rough estimate is that about 5% of the attendees are attorneys out of this conference. Now, what does that tell us? It tells us that there are very few attorneys that have dug this deeply or can invest the time, let's say, into understanding all of the nuances to the science and the research and where the field is headed. So I say that as just a background because we really need people who are doing this work, the Ryan Lillians, the Todd Wellers, who are doing this work to continue to present, to make sure that the labs are coordinating with the local prosecutors' offices to ensure that they're understanding where they're looking forward to. My understanding is that right now we're not going to see 3D comparison microscopy in court in the next year or so, but maybe if you look 5 years down the road or 10 years down the road, this is going to be a regular course of business. We just need some lead time to be able to understand it. Lawyers need a lot of time to understand these things. One of my main jobs is being that liaison between the scientist and the lawyer, because we have to kind of translate it into a way that's digestible for people who don't have the time to dig into it as much as we do, let's say, at this conference. So I would say continue, whatever lab you are, coordinate with your prosecutor's office to train them on what it means. Try to get more prosecutors that you speak with to join conferences like this. And then to the second part of the question, how will it impact post-conviction case reviews? It's a great question. I think that this is, I'm looking forward to seeing what results are. My understanding from the current 3D work that exists is that it really does support the examiner reliability. So the work that's currently being done by examiners has been bolstered by the 3D VCM technology that's coming up with the same results. So I don't expect there to be kind of an overwhelming post-conviction fallout from using 3D microscopy, but I do think that it will support the reliability of the field.
Thank you, Ray. And Amie, I'm going to pile on to what Ray said about the demographics of the audience. And this question then is for you. We do have an audience member, and we have several numerous audience members from the international community. And one from Australia would like you to touch on the relevance of the disclosure of past court performance in current cases.
Great question, and thank you so much for joining us. I don't even know what time it is for you in Australia, but it's really fabulous that FDCOE has pulled this together and that people from all over the world are joining. So again, the answer is a little bit, it sort of depends. Oftentimes, if there are inconsistent statements or inconsistent principles that are argued between different cases by an expert, that's the kind of thing that could be in the US considered as a sort of impeachment material. So if an expert said something in an earlier case that is arguably inconsistent, say, about the science from what the expert says in a current case, in the sort of case at issue, then the prosecution can have some obligations to disclose those inconsistent statements. So I think in an effort to just make sure that those things are being captured, we're perhaps drawing a little bit bigger of a bucket for those sorts of previous instances of testimony, so that the defense attorneys will have an opportunity to go through those themselves to see if there's anything there. So I hope that answers the question. I don't know if the same sorts of inconsistent statements, kind of impeachment information, disclosure obligations exist in Australia as they do in the US. But my understanding is that, that's kind of the idea for requiring information about these instances where people have testified in past cases.
Well, I thank you both for your participation and for the audience for some great questions today. That will conclude our legal aspects panel. We will now go to a break until 3:45 p.m. Eastern Standard Time. And when we return, we will have our chairs panel. Thank you again.